I said on the radio yesterday that I'm not really qualified to teach this class, and I'll tell you why. Because I'm not teaching the status quo. I'm not teaching what they're teaching in colleges. I'm not teaching what they're teaching in public schools. I got my education in the street. Through activism, taking on issues. One of the first issues I took on was when Karen and I got married. I hit the law library. We've been married 28 years. And someone told me that you didn't need a marriage license to get married, and I wanted to go find out. So I hit the law library, and that's, I think that was the first issue that I tackled, was what's a marriage license and how did the state get involved in marriage? And so my education has come through trial and error, study, learning from others, trying it on myself like a coat to see if it fits. If it doesn't fit, I take it off and try on another coat. A dilemma is reached when there's an unsolvable problem. And if you have an unsolvable problem, you're proceeding from a false premise. So you have to move backwards in time, not forward. You don't solve a dilemma by moving forward and throwing money at it or passing more laws trying to solve the dilemma. And that's where America is today. So my approach has always been to move backwards through the law and see if we can find a remedy by using the law itself, but not the way it's being presented, but maybe, no, not maybe, more of the original intention of what the law is. I believe the law is a very useful tool for solving dilemmas when it's applied appropriately. And I apologize, I see here, I did this presentation in another word processor, and bringing it over here, it looks like I've gotten a little crowded, so there's going to be a few mistakes like that, so I apologize right off the bat. So the name of this particular course, or this particular presentation, is called Jurisdiction, Distinguishing Sovereignty, Power, and Rights. And let's see if this is going to... And the reason that we're going to do this is because ignorance of the law is no excuse. Jurisdiction is an extremely critical element in law. If you don't understand jurisdiction, then everything gets collapsed. Governments become collapsed. Agencies become collapsed. And as individuals, we look at a system coming at us, and it's indistinguishable as far as its power goes. So jurisdiction helps us to make some distinctions in law that give us a little bit of power as people when we're dealing with government. Again, so jurisdiction is understanding how authority and power is exercised. Jurisdiction is understanding how power and authority are exercised. It is critical in the application of law and defending against the abuse and usurpation of power. The Declaration of Independence specifically says that when a long train of abuses and usurpations pursuing invariably the same object evinces a design to reduce the people under absolute despotism, that's a lot of big words and a lot of concepts thrown all together by the Founding Fathers. The people have a duty to throw off government. That's a tall order. How do we know we're even supposed to be having the conversation if we don't know what an abuse or usurpation of power is? Understanding jurisdiction helps us to understand abuse of power and usurpation of power. If Russia is over here exercising its law in the United States, we would immediately become outraged. Why aren't we as outraged when the United States government is over here in Colorado doing that very thing? Because we've collapsed the idea that the system of government in this country is just one big happy family, when in fact the Founding Fathers deliberately set it up as totally different. Understanding jurisdiction is a critical element if we are going to defeat the treasonous Cloward-Piven strategy.
Thanks a lot.
Who all knows what the Cloward-Piven strategy is? Okay, just a couple. All right, you're sitting down. Cloward-Piven is a political strategy outlined in 1966 by American sociologists and political activists Richard Cloward and Francis Fox Piven. They called for overloading the U.S. public welfare system in order to precipitate a crisis that would lead to a replacement of the welfare system with a national system of a guaranteed annual income and thus an end to poverty. Cloward and Piven were a married couple who were both professors at Columbia University of Social Work. The strategy was formulated in May 1966 in an article in a liberal magazine, The Nation, called The Wealth of the Poor. The two stated that many Americans who are eligible for welfare were not receiving benefits, and that a welfare enrollment drive would strain local budgets, precipitating a crisis at the state and local levels that would wake up call for the federal government, particularly Democratic Party. There would also be side consequences of this strategy, according to Cloward and Piven. These would include easing the plight of the poor in the short term, shoring up the support for the National Democratic Party, then splintered by pluralistic interests, and relieving local governments of the financial and politically onerous burdens of public welfare through a national solution to poverty. The strategy is focused on forcing the Democratic Party, which in 1966 controlled the presidency in both houses of the Congress, to take federal action to help the poor. They stated the full enrollment of these eligible for welfare would produce, quote, produce bureaucratic disruption in welfare agencies and fiscal disruption in local and state governments that would deepen existing divisions among elements in the big city Democratic coalition. The remaining white middle class, the working class, ethnic groups, and the growing minority poor, to avoid a further weakening of that historic coalition and National Democratic administration, would be constrained to advance a federal solution to poverty that would override local welfare failures, local class, racial conflicts, and local revenue dimensions. They were the ultimate objective. The ultimate objective of this strategy was to wipe out poverty by establishing a guaranteed annual income. Because the ideal of individual social and economic mobility has deep roots, even activists seem reluctant to call for national programs to eliminate poverty by the outright redistribution of income. The bottom line is this strategy was designed to overwhelm the system, completely overwhelm the system, kind of like what we're seeing with Obamacare. It's completely overwhelming the system. And Obamacare, if you'll go listen to some experts, was deliberately designed to fail. And I believe that. I had the privilege of listening to a ex-director of the American Medical Association in Montrose last Thursday, not this Thursday, but the Thursday before, who had been following the idea of healthcare since before Ted Kennedy died, since before its inception. And after he laid all the facts, and you can find some of those facts in the Watchdog newspaper, the latest one, his conclusion from his expert position was that it was never intended to succeed, but it was designed literally to bring America to its knees so that they could implement a national welfare system. So we may be there. So the reason for studying jurisdiction, and so the reason for this presentation is to give us a perspective of where we can draw a line between state and federal jurisdiction and begin to work to oppose a strategy that has at its roots the destruction of the American economy and the American way of life. So jurisdiction is a pretty huge issue. And so we're going to get into those particulars.
David,
so, yes, sir.
Can we find that, what you read somewhere?
If you go to Wikipedia,
Okay.
I pulled that right off Wikipedia, thanks for asking, and just look up Cloward and Piven, and it's not a secret.
Maybe at some point we could talk about a strategy to boycott Obamacare, maybe boycott the fines, get a national movement to resist.
Well, you know, I agree. We have to work inside the state of Colorado. What I like the idea is, let's stay local. If we can shore up our local communities and our counties, you know, that's within reach. And we're just going to have to let the rest of the country do what the rest of the country is going to do. This can't be a top-down movement. This has to be a county-by-county, community-by-community movement. So we'll start here on the western slope. I, for one, disagree with the idea of secession. We have at our access some good law if we would just learn how to use it. So understanding jurisdiction is critical in understanding how to use the tools that have been given to us. Jurisdiction applies to all branches and departments of government, legislative, executive, and judicial, and administrative. You're going to run every time you're involved in law, jurisdiction is somewhere in the background. Within the state, it's municipal versus county. Within the country, it's Kansas versus Colorado, or any other state versus any other state. Colorado versus the United States. Those are completely separate jurisdictions. Agency versus agency, BLM versus Forest Service, you know. They all have limitations on what they're authorized to do, and all these limitations come down through law. You can find it in law, and you can exercise this if a agency oversteps its jurisdiction, or if the United States oversteps its jurisdiction inside Colorado, or if Colorado oversteps its jurisdiction in your personal life. And on earth, nation versus nation. International law has its appropriate jurisdiction and venue. And what the system appears to want, and this is just a perspective and an opinion, but it appears to me what the system wants is to collapse our understanding to where we see this beast as one, when it's really fragmented. And it's fragmented by all kinds of jurisdictional restrictions and boundaries. So understanding where those boundaries exist and what they are and how they got there and why they exist is real critical in understanding this presentation and what this presentation ultimately will bring us. Jurisdiction. Some other words that the word juris is used in is jurisprudence, which is law. Jury, juror, juris, judge. So the word juris is law. It means law. And diction is the speech. My son Steph speaks with really great diction. So it's where the law speaks. It's the area in which a law speaks. That's what jurisdiction is, law speak. Here's some ideas of what kind of jurisdictions exist. Common law jurisdiction, appellate jurisdiction, that would be inside the judicial system. Criminal jurisdiction is distinguished from civil jurisdiction. You know, when a court sits, what kind of jurisdiction is it exercising? Well, it's a function of what kind of case is before it. But what comes first, the court or the case? You know, a municipal court can't hear a federal claim. That would be a federal court. And so understanding that each court is limited in its power and jurisdiction, and a court can't exercise jurisdiction it doesn't have. Concurrent jurisdiction, two different courts. You can raise a racketeering lawsuit inside of a state court or a federal court. We might need that someday.
Oh, yeah.
Special jurisdiction, original jurisdiction. I learned once that only the Supreme Court has original jurisdiction in cases involving ambassadors. So in a case where a foreign ambassador is over here on American soil and something happens, the Supreme Court would be the sitting court to hear that particular case. Territorial, yes, sir?
Question. It's my understanding that common law jurisdiction was very prevalent in our history, but from the last 40, 50 years, those courts have seemed to have been decimated to some degree. You can't even hardly find them anymore. Is that what you know?
Well, let's lay some foundations.
Okay.
I'd like to get there from a foundational point of view,
Okay,
rather than just make a bold claim. I believe that they are accessible. One example, who was the doctor that was Kevorkian?
Mm-hmm.
He was tried in a common law court because they couldn't find a statute to make what he did illegal. Right? So they had to invoke the common law, and they brought a common law action, and that made that court a common law court. So it's common law to hear that kind of charge. Equity jurisdiction, that's a type of civil action that involves balancing both parties with an equitable judgment. Civil jurisdiction, ecclesiastical jurisdiction, of course, that would go to courts. Tax jurisdiction, IRS. Admiralty, which deals in insurance and contracts, and the high seas, arguably the Uniform Commercial Code, the Uniform Code of Military Justice, things like that, military tribunals.